Good morning or good afternoon. I'm very glad to be here, and I would like to thank organizers for sending the invitation. I would also like to thank the Croatian Association for Maritime Law for electing me as an honorary member and pay my fees from that. And I'm very glad that I take part in this colloquium dedicated to Professor Pejović. The subtitle of this book is actually borrowed from the book I'm now working on. The book should be finished by next June, and the title is International Maritime Law and Practice, Comparative Law in the Context. It's informal, and I have signed contract, and I hope next year I will bring some copies here. I met Professor Pejović only once. That was some 30 years ago. And I remember him as a great gentleman, or as people in Dubrovnik would say, Goshpar. And he made a really strong impression on me by his knowledge and his the whole behavior. He was so kind, and got this book, which I brought with me to Japan. And because of this conference, I brought it back from Japan, and I use it heavily, particularly for the history part of my book, which actually what I'm now presenting is a part of a chapter on maritime collision. And it will be a lot of history, because if we talk about comparative law, we should start with history, and that's actually what was kind of argument I was having with Informa, what is special about my book, and it's history and comparative aspects. So it will be both in this presentation. And rules on collision are actually part of tort law, and many scholars of tort law also study about collision, because it's kind of this kind of cross-section between these two fields, because maritime law, as in many other areas, has special rules different from general rules, and one of these areas is a law of collision. So law of collision has moved from contributory negligence, initially it was from Roman law, then it moved to divided damages, which is kind of a relic of older rules, which remain as part of I think Peter was talking about that, of common law, still in some countries, which I think United States, but we should see that there is some change in that. And then we have the third stage, which is now, we are now third stage, we have comparative negligence. So these rules on liability move to these three stages, and I will give you kind of overview of each of these stages. Starting with Roman law. Roman law introduced actually something which is not now known today as contributory negligence. Roman law has made a distinction between two situations in case of ship collision. One is when there is a kind of accident, causa, when an accident happened without fault. In that case, there was no liability. And if there was a fault of both sides, then there was no liability. If one ship would be at fault, then there was a liability of that fault. So if a person suffers damage as a result of his own negligence, culpa, it is not considered to suffer any loss. That is the origin of the concept of contributory negligence. So when two parties, both are at fault, loss lies where it falls. There is no liability to each other. I can see in the first more details. If there is a wrongful damage, then there is a liability. If there is no wrongful, if it's accident, then there is no liability. And what is actually this lex aquilia was mentioned here, which is part of tort law in Roman law. And this is a famous case about a barber shaving a customer at open field where children were playing ball. The Italians always like football. Once upon a time they played the ball. So if by accident the ball would hit the hands of barber shaving customer at open, the issue is whose fault was that? Was it the barber taking a risk to shave customer to dangerous place? Was it fault of people playing balls, or it was fault of customer who took the risk to be shaved at such a dangerous place? And the conclusion was it's everybody's fault, which means there is no liability. So that is the general rule of tort law of lex equilia that as it was adopted in Roman law, and that became part of what is now known as contributor negligence in many parts of many jurisdictions, many parts of the world. So that was first stage. That was contributory negligence. So if both parties are at fault, there is no liability. Then we come to other roles or rules you find both, which introduce this concept of divided damages. So if both ships suffer damage, the whole damage shall be in common and be equally divided in a price half by half. There were various theories why this rule was introduced, but I think the most, let's say, logical one is that it took into consideration perils of the sea factor, same as general average. So if you take part in this kind of dangerous activity, there should be kind of divided damages between parties at fault, regardless of whose fault was higher and whose fault was lower. So this became part of, that's why we have in common law this rule, because this became part of English law. By an act of parliament, all the rules became part of English legal system. And then it was introduced in other common law countries. Then we come to third stage, comparative negligence, which was creation of civil law. French civil code did not contain rule on comparative negligence. I would like to make a terminological classification of terms comparative negligence and contributory negligence, because they're often mixed up. Very often you will hear that contributory negligence means liability based on proportion of the fault. But contributory negligence actually means what is original meaning, which means defense. If both parties are at fault, there is no liability. Comparative negligence, that as term was introduced and heavily used by American scholars. And I think that is something which more precisely reflects the actual situation when both parties are at fault and the fault is different. Liability should be divided based on proportion in liability. So in American law, they use both terms. And it depends because, as you know, American law has different jurisdictions. This is not federal law. So in some states, they still maintain contributory negligence as defense. In some states, they introduce comparative negligence, and they make distinction by term. But in civil law, you will often hear contributory negligence, which actually means comparative negligence. In French law, civil code did not provide any provision, any article which would deal with that kind of situation. But French law developed the principle of comparative negligence by giving it kind of logical interpretation. If both parties are at fault, it should be logical. The one who is more at fault should be more liable. And as a result, French law developed the concept of comparative negligence based on interpretation of fault, as is stated in French civil code. German law was more precise. They have this article of section 254, where fault on part of the injured person contributes to occurrence of damage, liability, and damages, as well as the extent of compensation to be paid depend on circumstances, in particular to what extent the damage is caused mainly by one or by the other party. That is actually the basis of contributory negligence as understood in civil law, actually meaning comparative negligence. So the fault is divided based on proportion in contribution to the damage. Japanese law is based on German law. It's one of the jurisdictions that was heavily influenced by German law. And then we have this kind of provision. If obligee is negligent, regarding the failure of performance of the obligation, the court shall determine liability for damages and the amount thereof by taking such elements into consideration. And this is understood that this is kind of divided damages based on proportion in the fault. Convention on collision has adopted that principle based on proportional fault. It's Article 4.1. If two or more vessels are in fault, the liability of each vessel is in proportion to the degree of the faults respectively committed. Now we come to station what happened to English law, which had divided damages until this convention was adopted. So what is English law? English law also has passed through some stages. This is a leading case from the 19th century, Woodrop Sims, saying each vessel bears its own loss in case of inevitable accident. This remains as it is. Damages are divided equally when both vessels are to blame. This was the relic of Oliver rules. So it was divided damages at that time. There is no right of recovery when damaged vessel is alone to blame, and damaged vessel is entitled to a full recovery when the other is solely at fault. The things have changed after ratification of Convention on Collision, which came, I think, I remember, 1911, just after the convention was adopted. And something which is very interesting development in the general tort law, English law. 1945, there was a new law, the law reform contributory negligence, which is called contributory, but actually means comparative, which came as the result of this convention, because law commission came to the conclusion that it would be strange to have two different tort liabilities, one applying only to collision, and another general tort rules. And as a result, because of influence of the convention 1910, the general tort law of England was changed by this act in 1945, and you can see how things that can be changed in that level of general tort law that English law has adopted through collision rules, has adopted different kind of tort law, which is based on proportionate fault. American law, as you probably know, that Americans often take part in drafting, but when it comes to ratification, they stay out. That was the case with number of conventions. That was the case with this convention as well. So Americans decided not to ratify Convention on Collision. That is also the situation today. American law has adopted so-called Pennsylvania rule, which is based on a case from 19th century. That was a very interesting case. I'm not sure if, yes, again, some details. So there was a collision between two vessels. One which was dominantly at fault, was large merchant vessel speeding in fog. Another was a small fishing bark moving very slowly, but giving using a bell instead of sounding foghorn, which was provided as ruled by what kind of call rate that was that time. So American court decided that both ships should be at fault. Even if one was dominantly at fault, both should be held liable. And this is a kind of, how to say, an unfair situation. Just imagine one large merchant vessel, like in this case, committing, being liable 90%, and one small vessel that is only 10% at fault. And then when it comes to the division of damages, they should divide it half by half. That is very, how to say, very harsh and I would say unfair, because even if this small vessel was small, it is still possible to inflict heavy damage on large vessels. Just imagine one tanker, large tanker, and one small yacht causing a leaking and damage of tanker. It is extremely unfair and harsh. And under Pennsylvania rule, they established not presumption of fault, but presumption of causation. So the owner has to prove not only that his fault did not cause the collision, but it could not have caused it. That is a high level, which is very difficult to discharge that kind of burden of proof. So we have, which is still in force at the moment, very how to say, harsh rule, which creates some sense of unfairness. And because obviously people don't understand this is unfair, there are some, as Americans in practical way try to solve that situation, they introduce kind of different rules to remedy this harshness. So they apply several rules. One is major minor. So if one, like in case of Pennsylvania, if one vessel is so much at fault, and the fault in the other vessel is minor, then this minor fault should be neglected. So the ship which was at major fault should take the whole responsibility, which is also maybe not fair because still the other vessel may have contributed to the accident. Another is the proximate cause, or you find kind of superseding concept doctrine when the actions of two vessels have taken part in creating the situation that led to accident, the collision. The court should find out which was the dominant cause, which is something very similar that we have in collisions, causa proxima. So this principle was also adopted in collision cases. If two ships are at fault, the court may look into circumstances to find out which ship was dominantly at fault. And last clear chance, which is another rule, when the plaintiff is making a claim against the defendant for causing accident, even if the defendant was liable for violation of rules, collision rules, the plaintiff may be held liable if the plaintiff had the last chance to avoid collision. That's famous donkey case. There was a donkey on the road violating the traffic rules, and the driver hit the donkey, and the owner of donkey sued the driver because by careful driving, the accident could have been avoided. So this kind of rule was adopted in several collision cases by American courts. And obviously there was something that has to be done. And actually that is United States against the reliable transfer. So we have a case that finally introduced in American law the principle of comparative negligence, which is now which replaced this kind of divided damages that existed for so many centuries. So we have yes, as I mentioned, there are some different states have different jurisdictions, but now because this is a federal law, in case of maritime cases, because of this case, United States against the liable transfer, finally, American law has introduced the principle of proportionate fault without ratifying the convention. And something again where American law is different, and that's actually the reason rationale of Americans for not ratifying the convention on collision. It relates to cargo claims. Under convention, the damages caused either to the vessel or to cargoes of the effects or other property of the cruise, passengers, other persons on board are borne by the vessel in fault in the above proportion, and even to third parties, a vessel is not liable for more than such proportion of such damages. What does it mean? What does it mean this? If two ships are liable for collision and the cargo on both ships is damaged, the cargo owner can demand only to proportion demand liability, only to proportion of the fault of respective carriers. In practice, this means that very often cargo owner would not be able to demand compensation from his own carrier, because many collisions, or most collisions, are caused by nautical faults. And as you know, nautical fault is an exemption from liability. So for Americans, this was not acceptable. They have preference for general tort rules, which means joint and several liability, because this is better protection to cargo interests. And as you know, American United States is dominantly cargo interest. And this was the main argument against ratification of Convention on Collision, because they wanted to retain general tort rules, which is, from the perspective of cargo interests, it's more beneficial. And as a consequence of this attitude, so-called both to blame collision was introduced by Americans and is now found in many bills of lading in many charter parties. You may have heard about this kind of clause. It's always when I try to explain to students, it's quite complicated. I'll try to simplify. What is basically the meaning of this clause? If you try to invoke benefits of joint several liability, and you make the claim 100% because you can do it under American law, to the other carrier because you cannot get compensation from your own carrier because of nautical faults, then the other carrier has the right of recourse against the carrier who carried cargo of the cargo claimant. And that is also possible under tort rules. So if both vessels, let's assume 50-50%. So under collision rules, collision convention, both parties should be liable up to 50%. And that is not acceptable to cargo interests. So to avoid this, cargo interest would sue the other vessel and get 100%. And the other vessel would sue the carrier who was carrying cargo of the cargo claimant. Basically, this would mean that carrier would be deprived of protection he would otherwise have under the Hague rules. And this convention actually says, if you use this, and as a consequence, I have to pay recourse to the other carrier, then you have to compensate me for losing my defense under Hague rules. That was the meaning of both to blame clause. The issue is that clause valid? And American courts found that in case of common carriage, this is null and void. Because in case of common carriage, there is kind of public interest, which is stronger than in case of charter parties. Charter parties, both parties are at equal footing, and they have possibility to protect their interests. But in case of common carriage, this kind of clause is declared null and void. Japanese civil code, they have the interesting separation between rules that apply to domestic carriage and international carriage. In domestic carriage, which means that two Japanese vessels would collide in Japanese waters and Japanese law apply, then Japanese civil code applies. And this means joint and several liability. On the other hand, in Japan, I think Japan was one of the first countries to ratify Convention on Collision, 1914, if I remember. They adopted, of course, since they ratified, they adopted in commercial codes, they adopted the rules of proportionate faults. So this may sound a bit inconvenient that in the same situation we have different rules, but that is at the moment that is Japanese law. One thing that I was actually thinking yesterday, so this is new slide, just came to my mind something conflicting in English law between insurance law and collision law and tort law. So how likely that English law may abandon causa proxima insurance law? The answer is very simple, not very likely. But as the lawyers, we can think about as a hypothetical question. Why I'm raising this issue? Because causa proxima means that you would look for one cause of damage, dominant cause, not first, not last, but dominant cause. And if dominant cause is on one ship, the other ship is not liable, which has some element of unfairness. Let's think about situation that one ship is 51%, another ship is 49%. Then, in case of collision, this would actually apply. But in case of insurance, you would look what is dominant cause, what is causa proxima, and if the other cause is less than 50%, no liability. Everything is based on what is dominant cause. Why am I raising this issue? Because it's separate. Because causation was imported into insurance law from tort law. So this causa proxima was originally part of English tort law at the time of contributory negligence. In the meantime, English tort law was revised, has been changed. So now it's proportionate faults in tort law. But in insurance, we still have this proxima causa. From the perspective of legal logic, I think English law should be revised, but how likely is not likely? Why? Because for English, tradition is more important than legal logic. So I don't think this is just a kind of little bit of gymnastic think about what should or what may happen, but what most likely will not happen because we have so many cases of in insurance law based on causa proxima, so I don't think this is something that would change, but okay, we can think about that kind of situation. And for the end, I would like to introduce something which is not really comparative law, but that is the case I was working, and that's because I'm not sure if I told you, I used to work as lawyer for a shipping company from Montenegro, Prekopjanska Plovila. So that was for me, that was a very precious experience as a young lawyer. So I was working in the most complex cases because they were not very familiar with maritime law, and I came from Japan with master degree, and then from Zagreb Pejović, because Jakša was my mentor. So they thought that I should be able to help them, and I was working for the company. That was the most important case. I'm most proud of this case, in which that was not a real collision. That was something that was mentioned when there is no direct contact with investors. But this is still a collision. This is indirect collision. So what was the situation in this case? That was in Ravenna, actually, in Italy. And this vessel, the Danilograd, I think it was called. The name of the vessel was Danilograd, and was under time charter. And when entering Ravenna port, there were this kind of, as you can I use as illustration. In many ports, they use this huge tires from trucks, which has a kind of metal fender on which it's posted, so that this is supposed to protect the vessel against damage in case of when before the vessel is properly secured by ropes. Very often the ship would hit these tires and would be protected because it would not hit directly concrete. Ravenna is a port which, in which case, narrow channel rules apply because it's narrow. And before the vessel was properly secured by ropes, there was another large vessel, Carnival was the name, passing, or it was supposed to pass close to Prekopjanska vessel at the moment of securing. And it was a very interesting case. So we could follow because they were in contact. Everything was in a logbook. And there were pilots on both vessels. And the pilot on our vessel was saying, wait a little bit more. But the pilot on Carnival was impatient. maybe it was some football match or a lady was waiting, who knows. So just maybe 2 or 3 minutes before the vessel was properly secured, Carnival started to move. And when you move, you cause waves, and the waves actually throw the vessel through this fender. And one of these, through this tire, and one of these metal fenders broke a hole in the ship's warehouse. It was fertilizer, and it was a total loss, but that was below seawater. The level of seawater was below. So the master, of course, when there was a huge impact, was a hit, and then because we got all witnesses, and he went to see if there is something wrong, and he could not see. It was a not big hole, it was a small hole, but maybe 5 to 10 centimeters. But when it enters this warehouse for a long time, for 2 days, of course the water entered, and it was a total loss. Just to dispose as a waste, we had to pay $300,000. It paid, I think, $1.7 million. I've been a few times to north of England, headquarters, Newcastle, to discuss. There was an Italian lawyer, and we had a discussion. And at the end, our vessel was set free, no liability. 70% was liability of Carnival for violating Colrex rules, narrow channel, and 25% was liability of charterer, because those fenders were not proper. It was a protection, because they're supposed to protect the vessel, not to damage the vessel. So as a result, we won the case, and unfortunately, that I was not. I can tell you something privately, which I don't usually say. I was not able to attend the trial because I was not able to represent, since I'm not a barrister, I'm not solicitor. But I was supposed to travel to England, to London, and then I was not allowed to travel by military authority of my country, because I refused to come a different way here to fight, because Montego was involved. So that was the situation when I missed the trial because of that kind of situation. That should conclude here. Hvala, I should learn one important word in Croatian. Thank you.